Hi everyone, it's Matt Lockaby with Lockaby Law in Lexington, Kentucky. If you've been following workplace news lately, you'll know that non-compete agreements have been getting a lot of attention in the national news. And that's because in January of 2023, the Federal Trade Commission issued a proposed rule that would ban nearly all non-compete agreements between employers and their employees and independent contractors. They followed that up after a fairly extended notice and comment period with the final rule, which was issued in late April of 2024. A few differences aside, the final rule also banned nearly all non-compete agreements in the workplace. So let's back up a second. What is a non-compete agreement? Well, it's a contractual agreement between an employer and generally an employee, sometimes an independent contractor, that prohibits the employer or the contractor from working for a competitive company for a certain amount of time and within a certain geographic scope after the employment relationship ends. Before the FTC's final rule came along, non-compete agreements were subject to state law, which was a patchwork of different rules and regulations from one state to the next. In general, in those states where non-compete agreements were legal, the restrictions were enforceable if they were reasonable with respect to the character of the restriction, the duration of the restriction, and the geographic scope of the restriction. And, in general, as long as the restriction protected or advanced or even supported a legitimate business interest. The FTC's final rule sought to bring some uniformity to this patchwork of rules and regulations across the country by banning the use of most non-compete agreements. I say most because there are a couple notable exceptions. First, non-compete agreements with senior executives were exempted from the final rule's ban. Senior executives were defined by the FTC as those individuals making a little more than $151,000 a year and working in a policy-making position. Second, the FTC's final rule also accepted or exempted non-competes that were entered into or bargained for as part of the sale of a business. And this makes complete sense in a lot of ways. First and foremost, it's because in an M&A transaction, parties are represented most generally or most often by their own independent counsel. And so this non-compete agreement is something that is subject to an arm's length agreement that's heavily negotiated by two sides. Quite different than the scenario where an employer presents a non-compete agreement to an employee and says, you have to sign this or you can't work here. The final rule was set to take effect on September 4th of 2024, but litigation challenging the rule was rather swift and immediate. Within a few days, there were lawsuits filed both in federal court in Texas and in federal court in Pennsylvania. These courts have come to opposite conclusions about the validity of this final rule as well. Initially, in Pennsylvania, the federal court denied the plaintiff's motion for a temporary injunction. What does that mean? The plaintiffs in that case had sought a ruling from the court that the FTC's final rule should not take effect. But the federal court in Texas granted the motion for a temporary injunction. Now, the court limited that temporary injunction only to the plaintiffs in that case, meaning there wasn't going to be a nationwide ban on the final rule that banned most non-competes, but that rule would not take effect and would not apply to the plaintiffs in that case. But a few weeks later, the federal court in Texas issued a final decision which struck down the rule in its entirety. Now we're left in a waiting period of sorts. The appeal period, or the appeal deadline for the Federal Trade Commission to appeal the federal court's ruling in Texas expires on October 19th. At this point in time, all we know is that the FTC is evaluating its options as to whether it's going to appeal or not. The plaintiffs in the case in Pennsylvania, however, have sought to stay that litigation because there's already a ruling striking down the FTC's final rule nationwide from a federal court in Texas. But that case continues to move forward, and there are deadlines, critical deadlines, coming up this week. So what does all of this mean for employers? Well, first, we don't have a final rule banning most non-competes from the Federal Trade Commission. So the status quo remains, and our patchwork of rules and regulations that differ state by state continue to apply to employers' use of non-compete agreements with their employees and their independent contractors. It's absolutely critical for employers to have a solid understanding of their state law on non-compete agreements, especially those employers that have employees in multiple states, because your agreements may differ and the law that's applicable to any particular employee may differ depending on where that employee is employed. This is especially true for employers with a remote workforce, multiple locations in different states throughout the country. There are some states, for instance, that flatly prohibit the use of non-compete agreements, like California, Minnesota, North Dakota, and Oklahoma. There are other states, for instance, that set a threshold for pay before which an employee can be subject to a non-compete agreement. For instance, in Oregon and Illinois, employees have to make a certain amount of money in order for them to be subject to a non-compete agreement. And still other states have restrictions on what types of employees can be subject to a non-compete agreement. So for instance, in Massachusetts, healthcare workers can't be bound by non-compete agreements. And in other states, this would apply to broadcasters or construction workers and other types of workers in different industries. In Kentucky, non-compete agreements are generally enforceable. However, they have to be reasonable with respect to the character. They have to be reasonable with respect to the duration, right? The amount of time of the restriction. And they also have to be reasonable with respect to the geographic scope. And finally, there has to be a legitimate business interest that supports or advances the restriction. In addition to state laws, however, the Federal Trade Commission is actively filing enforcement actions against employers for their use and alleged abuse of non-compete agreements. The FTC was active in filing these actions against employers even before it issued the final rule. And the FTC has targeted several different types of non-compete agreements. First, it's looking at non-compete agreements that employers impose upon low-wage and low-skilled workers. And it's also looking at employers' uses of non-compete agreements with employees in heavily concentrated industries. There's certainly much more to follow as the litigation challenging the FTC's final rule works its way through the court system and as the appeals are filed, but we do see this issue eventually ending up at the Supreme Court of the United States. Stick with us. We'll keep you updated at every step along the way. If you've liked this video, hit the like button and follow us. We'll see you next time.